be careful when you work with family to begin with. There are a lot of successful businesses that are run by family members. So it's definitely not a taboo kind of structure, but you have to be careful because obviously there's a different dynamic when dealing with a family member or a friend for that matter, a close friend. You know, I don't concentrate in probate work, but I've done enough to know that you see really good people acting poorly when a relative dies, and you have beneficiaries and you have fights over that. So if you see that, and then you have to rely on the trust or the will that's been created by the deceased, and there are even fights once those documents are created, especially if they are not written tightly, or even if they're written tightly, there may be some circumstances that come into play that just really couldn't be anticipated by the attorney. So you see those types of fights. So just imagine in business where things get heated and a family member doesn't think they're getting a fair share or is working harder than the others. So absolutely, I think it would be imperative to have written agreements, whether that be for ownership interest, whether that is for the management, who's responsible for the management, and what titles people get, and actually what kind of obligations come with those titles and what entitlements come with those titles as well. That can all be spelled out. And if there are hurt feelings when those are being drafted, then you know right away how bad it's going to be if an issue, and it's probably not going to be if, it's going to be when an issue pops up, because you can already see that there are issues. So it's good to have an objective third party, usually an attorney, to be able to draft those types of agreements. And it's not excluded. In fact, it may be more important when you're dealing with family members because you have that emotional dynamic with it.